Hi everybody, it's attorney Brooke Goff. This is one of my pop-up Facebook Lives. I promised you all, hopefully the angle with the camera is better. I'm messing with the tripod a little bit so it doesn't make it look like I'm looking up or down. So I had put out a poll last week. Some of you that follow me may be aware of this, and I'd asked, what do people want to know about? Slip and falls, motor vehicle accidents, workers' comp cases, like workers' comp 101, what is it? And everybody seemed to vote, not everybody, but many people seem to vote for this workers' comp 101. So I do these a lot, and I'm going to continue doing them because I think it's so important that as an attorney, we share our knowledge and we educate you, because that's key. What I say in these, we'll call it seminars, is not to take the place of actually having an attorney for a case. I'm not teaching you how to do your own case. What I'm doing is teaching you the process so you can make an educated decision as to whether or not you choose to handle your workers' compensation case yourself or you want to get an attorney involved. My recommendation, I'm going to say this at the end of this, I'll say it now, is you should always have an attorney in a comp case. And you should at least always meet with an attorney in a comp case. A good attorney, if you have a case that you could really handle yourself, will tell you that. They're going to say, look, you hurt your finger, you have a lower comp rate, but this is, you should handle it yourself, but this is what you should do, kind of a thing. We regularly do that. It's not a turn away thing. It's just that you're going to not get much anyways in some certain situations, and you don't need to be paying an attorney a fee when it could be a straightforward situation. So first, I have met with so many clients that find me on Facebook, which is great, and the one thing that continues to come up is mileage. So I'm going to start this, weirdly enough, talking about mileage. People, mileage with workers' comp right now is the highest I have ever seen it. Okay, it's like 58 cents a mile. It's jumped dramatically. Like, I think it jumped by like 4 or 5 cents. What does that mean? Round trip to and from your doctor's office, workers' comp is responsible to pay for your miles. Yes, your miles. Why? I met with a gentleman the other day, very nice man. He's had a case open since 2012. Multiple surgeries, multiple physical therapy visits, just you can't even imagine how many. This man did not know about mileage. Why? The insurance company didn't tell him, because their job is not to tell you. Why would they tell you something that's going to cost them money, right? And we have a plan in place where he's going to submit me 5, then I'm going to give him 5 back, and then he's going to submit me 5, and I'm going to give him 5 back. This guy's probably looking at several $1,000s of mileage, just mileage reimbursements. It's a lot of money, and when you're out on comp and you're already getting a lower comp rate, which we'll talk about in a minute, these little mileage checks, if you submit them once a month, are a lot. So your attorney, no attorney should take a fee on those, by the way. So if you ever meet with an attorney and they try to take a fee, again, run is my famous saying. No attorney should take a fee on miles, okay? It's part of the case. We process it. You give me your mileage forms. My paralegal sends them in, and then we get you reimbursed for your mileage. It's not that hard, all right? And we'll also help you in calculating the miles if you need be. We do that with some of the clients, but a lot of clients, they kind of do it themselves. But it's round trip. So let me make some clarifications here. You leave home, you go to work, you go from work to the doctor, and then the doctor back home. You get round trip miles, okay, from work to the doctor and the doctor to home, even though you would have gone home anyways, right? It's round trip miles. It doesn't have to be round trip to the same location. People get confused by that. Miles, it's like 58 cents a mile, people, okay? They don't tell you this stuff. People have no idea. And what I'm going to tell you should know, if you've never heard of this and you have a comp claim going on, this is a perfect example of why you need a lawyer, all right? So number 1, miles. Any questions, reach out to me, Facebook message me, email me, text me, I don't care. I'm available, I'll answer your questions. Forms. Firstly, this is like the workers' compensation, and it's backwards, I can't figure out how to fix this, but this is the workers' compensation Bible, so to speak. So every year there's a new Bible. See how it says, I don't know if you can see it, 2000, oh Jesus. Well, the bottom you can see 2019 if you really use your efforts. So this is the book for 2019, right? It's actually a pretty color. Every year they come out with a pretty color. Last year, I don't remember what last year's was. 17 was red. Last year, the year before that was green. One year was yellow. They come up with all different colors. But this has all the forms in it and everything else. You can get one of these at your comp office. I post pictures of this and people are like, I've never seen that book. That is scary. If you're handling your comp case, you need this book, okay? You need the book. Go to your comp office, pick one up. When you go to your next hearing, or just go pick it up. You can find the materials online. I'm a hands-on person. I like the book. If for any reason I just sit here and go like this because when I'm trying to figure out an issue, I don't know, it seems to help when I can look into a book. I don't do Kindles either. I read paper books. It just helps me. So if you're like me, then this book is going to be beneficial for you. This book is not to take the place of an attorney, okay? This book is to show you how many things are variable in a comp case. And all this stuff is on commissioner discretion, which means the commissioner decides how to apply most of the stuff in this book, all right? So one commissioner might apply it one way, another commissioner might apply it another way. So just keep that in mind. This book is not to replace an attorney. This book actually, after you read it and you look at it, should show you why you should have one. So in this book, you'll find forms. These are not the forms you actually fill out, guys. Don't rip a page out of the book, fill out the form, and give it to the comp carrier. Don't do that. The forms that you fill out are actually online. So let's say you got hurt yesterday, right? Well, I'm going to tell you, first thing you need to do is get medical attention, right? You got hurt at work, my back hurts, I bent over. You're not going to, I can tell you this, they can't fire you for being injured at work and bring in a claim. If they do that, you have a whole nother claim that's probably worth more in some cases than potentially keeping your job, all right? So they're not going to do this. They don't do it often. If they do it, then the attorney you meet with is going to file a different sort of a claim, a wrongful termination claim, possibly a CHRO claim, depending on what the facts are. So you get injured at work, what do? Well, call an ambulance, make sure you tell your employer as soon as possible, okay? If the hospital is leaving you out of work, tell your employer. You have to communicate that, all right? Your employer's not a mind reader, and if you have an employer that you don't really care for, just take a picture of it, send it by text, just make sure you have a record that you gave it to your employer, because you don't want them to say, hey, look, Joey didn't come to work today, and guess what? We're firing him. You don't want that to happen, all right? So don't do it, not worth it, and you need to report it to your employer. This isn't a secret. You're not going to get in trouble. Be honest with the hospitals. I've had clients tell the hospital, hey, I fell at home. When they were hurt at work, they realize it's a significant injury. They can't pay for the medical bills. Then they come back and they hire me, and I'm now like climbing up, the rung, trying to fix the problem that they created when they could have just been honest in the first place. You're not going to get in trouble. Report accurately. Tell the hospital, the doctor, whoever would happen if it happened at work, and the rest of it will take care of itself. They can't fire you for it, guys, okay? Can't do it. Another thing people have an issue with is, okay, well, if I hire you, my job's going to get mad. I hired a lawyer. Let me just share something with all of you. The employers and the carriers love when you hire a lawyer, okay? Love it. Couldn't love it more. Why? Because pro se parties, like what you would be if you're not a lawyer, have a lot of questions and don't understand the procedures and the rules in place, regulations. So you may ask for a hearing on something that you shouldn't have a hearing on because it's obvious, and now the carrier has to pay their attorney to come down, and then you have to go down, and it creates a lot of drama for them. The other thing is when you have a case against your employer, it's against your employer, but they have insurance, and guess who every single case the insurance company is talking to? Their team of lawyers. You are going up against a lawyer on your own pro se. Not a smart situation. It's not. So when you think something shady's going on, or this, that, and the other thing's going on, or the insurance company's like screwing you over, whatever the case might be, you got to remember, they have lawyers that they're talking to. It's not like you're on level ground. You're a non-lawyer and they're a non-lawyer. No, you have an adjuster who's got a lot of experience with the insurance company. Then you have lawyers that work with the adjusters, or for the adjusters, I should say, and they're directing the adjusters on what to do. So now it's you versus a lawyer. And I can tell you right now, if I'm a non-lawyer, I don't want to go up against a lawyer, especially in workers' comp, where it could affect my job, it could affect my pay, it could affect a lot of my future employability. I wouldn't want to do it. So just FYI. Getting back to the book. So the book, these forms are going to be signed. Guys, I don't understand. I don't know why the phone won't let me do what's called a mirror. My Samsung used to do this. iPhone won't. I will figure it out. But for right now, just bear with me. You can see the forms. I'll say what they are, and then you can Google them. So this is a 30C, right? So there it is. Boom. Again, don't rip out the page out of the book if you pick up this book. Just look at it for reference, all right? So a 30C form is your notice of claim. You have 1 year to file this form. It's got to be certified. Your employer's not going to follow it for you. That's called a first report of injury form, and that doesn't count. It counts, but it doesn't count as a 30C. All right, 30C must be filed by you. If you're considering getting a lawyer, your lawyer's going to file it, and they're going to file it a certain way. So if you're considering getting a lawyer, I would say make that decision and then have your lawyer file it. If you are hell-bent on handling this yourself, then I would tell you that you should you need to file this 30C right away, and it needs to be certified mail. There's no getting around that. You can't send it first class mail because it won't count, okay? You have to put a certification page on the back saying that you sent it to the parties involved. It has to be workers' comp you send it to, and then you got to send it to the employer, okay? Just like that, workers' comp and the employer, they have to be certified. That needs to be done within 1 year. Not 1 year and a day, not 1 year and 2 days, within 1 year. If you don't, you could potentially be forfeiting any benefits, and or the viability of your claim could be at risk. Don't do it. It's stupid. Simply do it the right way, okay? The first thing I would do after I went to the hospital and I realized I'm okay and everything else, you should file this form immediately, all right? 30C is what it's called. Now, you're going to get something in the mail back from the insurance company with that, right? So they're gonna then file what's called an appearance. Their attorneys are probably gonna file an appearance in the file, or they might file it given if you're pro se. But they have, again, attorneys that are working with them. They will file this form probably. It's called a Form 43, right? Just like that, boom. In this form, they're going to say, no matter what your injury is or the situation, most of the time, they're going to say John Smith was not injured within the course of his employment, and therefore we're denying the claim. Guys, this must come certified too. It doesn't mean anything, all right? This is language that they have to use. But once you get this form, you need to file for a hearing. It's called Form 43. Some commissioners say, Brooke, why do you always file for Form 43 hearings when you get them? Because I want a record. Because I want it to be on the record that we don't agree with the Form 43. Because every client deserves to be part of the record. And yes, I will schlep to a hearing to make sure it's on the record. Some commissioners are like, don't bother objecting to it, just part of the record. Well, you're going to hear my part of the record, which is we object to your Form 43. I don't care if it's procedure. We file them. We object to these things. That's the way it is, okay? So you have to do what's called an informal hearing request, which has got to be one in here somewhere. And that informal hearing request, maybe there's not. You can get it online. I'm surprised that, here it is. Yeah, I was going to say this is like one of the major ones. That's an informal hearing request, and your reason for the informal hearing is a Form 43, all right? So you might get something else in the mail, and this is called a Form 36. This is the employer trying to cut off your benefits, the insurance company. Trying to cut your benefits off. It comes certified. You only have a certain amount of time, 15 days, after your receipt to contest this. It's an informal hearing request I just sent you, Form 36. If you do not, your benefits will stop or they will be changed over to a new type of benefit. This is bad. Always object to this, okay? That's a Form 30. On this, it looks like it's 63, but it's a 36. It's just backwards, just like that, okay? This is all the stuff that's important, and this one I'm telling you that it's important because this is why lawyers being involved are necessary for you. I've showed you most of these forms that you've never seen, even if you've been handling your cases on your own. Guarantee you've not seen most of these forms. And that's scary because you should, because you need to know how to protect yourself. If you don't even know the forms, how are you going to protect yourself? Okay, the next big form is called a Form 1A. And find it in here. It's one of the main forms. Should be in here. Just bear with me a second. Here it is. Form 1A. This is how we figure out your wage rate, right? So I actually have a system in my office where we plug a bunch of numbers into, and it pops me back what your comp rate is. So I can do an example for you. And I'll be looking at the computer, so just bear with me here. But I'll do a little plug and play, and you can see what the differential is. Then we'll get into wage rates a little bit. So the program I use is called Comp Tools. You need to be approved by them. I believe you have to be an attorney to be approved. I'm 99% sure that's the case. And because it obviously allows you to calculate comp rates, and it comes with a hefty annual fee. So let's just say somebody got injured on November of 2018, right? And they were making $1,000 a week before they got injured, all right? So your average weekly wage is $1,000. They're married, filing jointly, and they have no kids, right? So you plug all that in, and I'm popping out a comp rate. This person should be getting a check for $634.26 a week. Now, again, this takes into account a lot of different things, and this is comp rate issues. So most of you you get 66 2/3 or 68, whatever. Honestly, you can't really pay attention to that number because you get points back for exemptions, you get points back for well, not anymore, but you used to. You get points back for your filing status. So just FYI, this person that makes $1,000 a week before taxes, okay, now is going to be getting a check for $634.26, which is probably about $125 less than this person gets when they're not on comp. That'd be my guess based on what I'm seeing in front of me. So the point is, this shoots out your comp rate, okay? We can only do that when we have this filled out, right? And this should be submitted to the insurance company. If this is not submitted to the insurance company, you're at risk of being paid the wrong comp rate and then having us have to go back and fix it after you decide to hire a lawyer a year later, and it's just not a good scene, okay? 1A form needs to be filed. It should be one of the main forms filed after the other side has gotten involved. Now, another form I'll show you is called a Form 42. So let's say you get, I don't know, you hurt your back and you need surgery in April of 2018. April of 2019, you might be ready for an impairment rating. This is what the doctor fills out and sends to the other side. This is another important form. It's called the Form 42. Most people don't know this. When you're injured, about a year after your injury, you can get what's called a final impairment rating. Now, most people don't know this, and the insurance companies don't tell you. So, if you go to your doctor and get an impairment rating, and let's say it's 10%, and they send you to their doctor and they say it's 5%, if you sign the green papers that come with their rating, you've accepted their doctor's rating. Why would you ever do that? Your doctor's telling you 10%, and your doctor's seen you probably 20 times at this point, and their doctor's seen you once, okay? Why is that a problem? It's a problem because people are losing thousands and thousands and thousands of dollars. Let me tell you, on a back injury, how much, and I'm just going to grab, I can't grab my phone, I'm on it, but I'm going to sign in here and tell you what the difference is. So let's say your doctor gave you a 10% rating of your back, right? That's 37.4 weeks of pay. So if you're making $500 a week, right, let's just say, then that's equivalent to about 37.4 times $500. So that's equivalent to $18,700, okay? If their doctor gave you a 5% rating and they sent you the green forms, you didn't know any better and you signed them, right? With their doctor's rating, that is going to cut that down to $9,350. So you just gave up $9,350, which is a week differential of 18.7. So you just gave away 18.7 a week. So that's what? 4 months, 4.5 months? Why would you do it? You don't. But you don't know any better because you're handling it on your own, and workers' comp is not really claimant friendly. All right? This process is very complicated, and you got to understand that. And your step to being successful in the process is understanding the fact that there are lawyers here for a reason. Now, not all lawyers are good lawyers. It's just the way it is, right? It's like that in anything, real estate, criminal, everything else. Meet with a lawyer. See how comfortable they make you feel. Ask them questions. They should be, when you go to an attorney meeting, they should be throwing information at you. If they're not, you have a problem. Because if they're just regurgitating the stuff that you gave them, you could do that yourself. Why would you pay a lawyer? So that gets into the payment of lawyers, right? So we get 20% at the end of the case. All right? That's what we get. So if I have to go to 10 hearings and you continue getting your checks weekly, I don't touch those. When you're out of work and you're going to I go to 10 hearings and this goes on for 2 years. Let's say you're out of work and you're getting checks. And then you're given that Form 42. I send the 42 to the doctor, he gives you the rating. That's what I get my 20% of. Or settlement. So settlement consists of benefits owed to you as a result of the incident. And typically what's called PPD, that rating, is a part of that settlement. All right? The issue is sometimes they come in two parts. So the attorney's fee is 20% of that one thing, but it could come in two parts, okay? So it's still the same. If the one was 20 and the other was 80, then the attorney's fee would be 20% of 100, right? But if one came as, okay, so one came as 80 and one came as 20, the attorney would get 20% of 20, 20% of 80, right? Which is still the same as 20% of 100. So we get the same. It doesn't make a difference. It just can come in two different parts. The point is we get paid at the end. So we are like an afterthought for you, okay? Way, way, way at the end. So it's super important that you understand that we get paid at the end. And it's only if you get, let's say you don't get a rating and they don't want to settle, we work for free. It's the way it is. There's no risk to you. The only risk you have is actually having your case handled appropriately and properly and by textbook, because that's what you deserve. A lot of attorneys are out there. They open their offices in the comp office, but they're like mills, and you go in and like, okay, thank you, and da da da. You don't hear from them forever, or you don't know what's going on, or you know they don't give you a lot of information. You just kind of figure they know what they're doing because they're in the same building as workers' comp. That's not the case. Your attorney needs to educate you. They need to take your calls in a reasonable time, and they need to make you feel like your case is being handled appropriately. I mean, 20% is, at 20%, attorneys don't make as much money on these cases as they make on third-party cases, which is like car accidents. We make a third on those. But comp case, I got to tell you, some of my best clients have been comp clients. And some of the people we help the most in this entire world are comp clients. And it's great. Nothing's better to me than when somebody comes in, they sign up with us, and then we close the case, and they're ecstatic. I know that they've gotten every dime they're entitled to. We fought for them, and they're able to start their life and get some closure. So, again, that's just kind of a synopsis of workers' comp, the forms, the miles, and the attorney stuff, right? So let me just real quick. Unless you work for a healthcare provider like Harvard Healthcare or Yale, you have your choice of doctor. Yes, you have your choice of physician. They want you to go to Concentra once. Who cares? But you need to make that choice up front. Don't come in 3 months later and be like, Brooke, look, they've been sending me to Concentra. I don't like Concentra. I don't like them. And I'll be like, John, how many visits have you had with Concentra? Oh, I've gone there 6 times. You know how difficult it's going to be for us, no matter you, to change Concentra from your provider. You were complacent. You didn't do anything. You have the choice of provider, but you have to make it up front. Because if you don't, right, and then you don't like what they say down the road, because if they rub you wrong now, they're going to rub you wrong even worse later. Then the problem you're going to run into is that now you're not going to be able to change your provider. You're stuck with a doctor, an actual facility that works for the insurance company and your employer, okay? Why you would do that, I don't know. And you're going to be screwed. I've had more people, and this I will say from doctors that work directly with the insurance companies. So Concentras, OcHealth, these types of facilities, not these ones, I'm not saying that, these types of facilities that have not, we have ended up, when the client goes to a specialist, we end up finding things that were missed, okay? And that's a big deal. And if you're stuck there, you're screwed, right? You don't want that either. So you have the choice of doctor. I'm not going to say any particular doctors I recommend on the air right now, but if you want to message me, I'm happy to share with some really good ones. I always set my clients up with when they ask questions about good fit providers and stuff. If they're not going somewhere where I think is good for them, we always set them up, and they're very, very happy with our recommendations. Board certified physicians are always the way to go. Okay, a physician that you should be seeing. A physician overseeing you the entire time, one physician. Now you might see their PA, that's fine, but that physician should be signing off on all your medicals. If you don't know which orthopedic you're going to see when you walk into the door of a hospital or one of these occupational places or what have you, that's a problem, guys, all right? This person's supposed to be like making sure that you can return to work when you can return to work. You don't want to get involved in that, all right? So don't do it. It's stupid. Do not do it, all right? Choose your doctor. Choose them out of the gate. Choose somebody wisely. Because that's going to come back and haunt you later. And check reviews. Google's a beautiful thing. Hey, you guys can all check me out on Google, Goff Law Group. We have all 5-star reviews, and then one person, we do not know who it is. We tried figuring it out. We don't know. Nobody I've ever represented left me a bad review, but I think that they just didn't appreciate my videos. I don't know. But and that was like over a year ago. But it was never anybody I represented. We tracked it back, so I don't know. They don't realize how much reviews can actually make a difference for people, which is okay. But with doctors, you've got to read those reviews. Get nitty gritty. Open them up. See, if somebody gave them a 1-star review, you want to see what they said. Misdiagnosed, didn't take care of me, didn't care. Read that stuff, because that's the stuff you need to see. All right. But you get to choose your provider. You need to choose it. Figure you can't see their doctor more than 2 times, 3 tops. I'd say 2 tops. Without there being an argument from the other side saying, hey, look, they're treating with our doctor. They accepted them. This choice doesn't follow you. You can't bleed the well dry, so to speak, with their doctor, kind of figure out, I don't like them, or they say something I don't like, and expect that they're going to let you see somebody else. That's a problem. Okay. Don't want to see it. All right. Comp rate. I went through that. Settlement. Guys, workers' compensation does not require insurance companies to settle cases. They don't. It's not the rule. So why is it good to settle your case? Well, it's good for them because then you're not on the dole anymore and you're not a risk to them. It's good for you because you get a payout, which you'll probably not see that much in benefits, and then you can get some closure and move on, right? So in workers' comp, there's settlements not required. This is one of the largest benefits of having an attorney. When you have an attorney, they want to settle your case. They want to move this down the river because they know that if there's a misstep or something else, the attorney will be all over them. So, guys, the settlement's not required, but having an attorney will help in getting your case resolved. And most of the time in settlement, we can get you benefits that you're never going to see down the road. Not required, so you have to have somebody that's good, that can put it all together and be reasonable in the settlement so that you can get it done, because that's what you pay us for. So I hope this video has taught you guys a bunch of things. 1, you have your choice of provider. 2, forms. 3, miles. 4, doctor choice. 5, why it's important to have a lawyer, and I could go on about that, but I won't because I don't want to bore you all. And I really don't want to come across as biased. I'm not being biased. I love my comp clients. We do well by them. They love us. We do really good work for people, and I just think it's so important that people realize the value of having an attorney in a comp field. And I hope that you see how much I talked in this, 15 minutes or whatever, and all the things you probably learned. If you learned anything in this conversation, you probably shouldn't be handling your case yourself, because as an attorney, I'm only skimming the surface. This is the easy stuff. This isn't the stuff that we deal with on a daily basis when John has a family of 4 with a mortgage that has checks late all the time, or Jane has, was released back to work and still can't walk on her leg and now wants to change physicians and can't, or Jim that thinks he's being paid underpaid. They're telling him he can't get his overtime, and guess what? Yes, guys, overtime is calculated as part of benefits. Or Sarah that has not gone back to work and hasn't gotten a check and didn't even know she was entitled to a check. Or Jane that was hurt at work 3 years ago and never got an impairment rating and therefore just thought it was over when she stopped treating. Wake up, guys. Wake up. This is what I do. I'm very good at it. This is what my office does. We have a great comp practice. Wake up and make a decision that's going to affect you for the rest of your life. Have an attorney look at your file. Hire up. You get an attorney. If you get in a comp case, one of the first things on your mind is, which lawyer am I going to call and when? Hopefully I'm on the top of your speed dial. If I'm not, there's many attorneys. Just make sure you do your research. If you need more information about me, Goff Law Group, as you know. I'm on social media. Clearly, you're on Facebook. Follow us, guys. Like us, follow us. I do these videos all the time. We do contests, fun, Trivia Tuesday, all that stuff. I'm on 104.1 in the morning. All of you better listen in. Between 9 and 9:45. Tons of comp questions. You'll definitely learn something from that too. And I can be reached on the office, 203-399-0000. Text is 203-913-4179. Not for long. You're going to be able to text our office line very soon in the next couple days. It's a new program we have in place, and it's awesome. And I did it for you guys because my clients love text, and this will streamline my text much easier. So if I'm in court, one of my assistants can answer it for me. You can email me, Brooke, BROOKE, @gofflawgroup.net. No question is a stupid question unless it's a question not asked, okay? My grandmother used to say it. I stand by it. It could honestly be a $100,000 question. You don't know. So we speak Spanish as well. I personally don't. I will be doing Rosetta Stone very shortly, but I have staff here that speak Spanish, so they translate for us. I email in Spanish. I write it. So you guys, we accommodate our clients. We go above and beyond to do that. So again, reach out to us. Happy to help you guys. I hope you learned something. Any questions, feel free to reach out. Something I said, hits a nerve. It's probably a reason for that. You're seeing this video and you think, oh wow, this is weird. This is like perfect timing. It's not perfect timing. It's because you're supposed to call and you're supposed to get some advice in your case. Again, Attorney Brooke Goff. I'm going to sign on for now. Sign off for now. And any questions, feel free to reach out. Follow us on Facebook. Thanks, guys, and listen tomorrow, 104.1. Thanks.